Thank you very much. I said I was going to unmute. So good afternoon, everybody. My name is Alison Tilley, and I'm a part-time member of the Information Regulator, as well as the coordinator of the Judges Matter project. I think what I really would like to do is focus in on the role of the regulator and legislation in protecting privacy. We're talking here about the right to what we call informational privacy. The protection of personal information it forms an element of safeguarding people's right to privacy. It's the legal protection of people where your personal information is collected, stored, or used, or communicated. In South Africa, the right to privacy is protected in terms of the common law, so the law that isn't written down in legislation or in the Constitution, but it's also protected in the Constitution itself in Section 14. The recognition and protection of the right to privacy as a fundamental human right provides an indication of how important it is. It's not an absolute right. It may be limited by a law of general application. It has to be balanced with other rights. It's one of the reasons the Information Regulator was set up to regulate both the right to privacy and the right to access to information, because they're two sides of the same coin. You don't want your personal information made available inappropriately, but on the other hand, you do want transparency. So how do you get both? The best of all possible worlds. And the argument, I think, is that one of the ways of doing that is put those powers in one regulator and see if they can do that balancing act. If we look at where this concern about information protection has come from, it is pre the internet, as Mark says. There is really the development of computers, the growth of centralized government, the development of massive industries holding information. We previously have had placed in one, now have records that are available, across the world. The surveillance potential of all of these computer systems has prompted demands for specific rules which govern the collection and handling of personal information. So the question is no longer whether the information can be obtained, because it probably can, but the question is if it should be obtained, and where it has been obtained, how it should be used. So if you're going to allow the collection of personal information, which we do, then you have to make sure that fairness, integrity, and effectiveness for collection and use is also promoted. It is something that has to be applied cross borders. Its information is slippery and it moves around the world. I'm not sure if it's technically at the speed of light, but certainly quickly. What we did in South Africa is really look to what we would regard, I think, as the gold standard of data protection, which is the European Union data directive. And what we did in South Africa is put together the protection of relates the access to and how people are entitled to process personal information. Now, as I said,
Alison, just one second.
That is limited in South Africa. We only have jurisdiction in South Africa, and information moves everywhere. That is a limit, and one has to deal with that in different ways. But as a statutory regulatory agency, we are able to get notifications of processing where it's special personal information. We can conduct investigations. We use a system of notices where we're unable to conciliate or mediate conflicts around how personal information is used. I think just to perhaps to talk less about the regulator's powers, but to just jump into one of the issues that we're dealing with at the moment, which is the question of WhatsApp and their terms and conditions. And WhatsApp is end-to-end encrypted. They can't, WhatsApp and probably not anybody else can read your messages, but what they can read is the metadata. And that's the interesting thing. So that's what makes their money is the metadata and not the content of the communications. And WhatsApp has a privacy policy that is pretty good in Europe and then not good everywhere else. And the regulator in South Africa has taken the view that we should at least get the privacy protections of Europe. It does seem reasonable that Africa should get less privacy protection than our friends in the European Union. And so that's one of the things that the regulator in South Africa is looking at and is asking WhatsApp why their privacy policy is not better. And that's something that's ongoing. I think just in the context of state surveillance, it's worth noting that South Africa has taken a rather unusual position in relation to these kinds of critical information databases. The word critical is used just as a sort of a way of describing that. Basically, when you have state security and the information they put together, in most jurisdictions, that information and that regulation of that information is exempt from the provisions of your privacy legislation and falls outside the ambit of your regulators' jurisdictions. In South Africa, we haven't done that. What we've done is we've said that the right to privacy and the jurisdiction of the Information Regulator do apply to state securities information until such time as they pass or have passed for them their own legislation, which protects the information, the personal information that they gather, but specifically in their context. And they haven't passed such legislation, and so are currently part of the regulator's mandate. Just to balance it out, to say that, of course, privacy and informational privacy are very important and are acknowledged more and more. So I think when we talked about privacy 10 or 15 years ago, people were like, well, who cares? But I think we've really got to the point that people certainly do care. But of course, what people also care about is getting information that's important to them. And there, the regulator has a role around access to information, and we have the order. I would like to just do a little commercial for using the Promotion of Access to Information Act. We do have order. We've had very little uptake so far, and I think some of that may just be the exhaustion of everybody with PIA over the last 20 years and how badly it's worked. But the intention is that the regulator will be able to take on complaints around government bodies and private bodies not releasing information. That's also an unusual legislative wrinkle in South Africa. We include the private sector in the ambit of our Promotion of Access to Information Act. So in most jurisdictions, you can only get government information, but we are able to access privately held information. And if you look at the statistics at the Information Regulator so far, I think it's over 60% of the requests are actually against private bodies, and they're looking for private information or private information held by a private sector body. So there is legislative frameworks for these things, and of course, like any legislative framework or any government agency, although we are independent and not part of government, the only way the thing works is if people use it. If you don't use it, it doesn't work. And I think for a lot of campaigns where you're thinking about working over 2 or 3 or 4 years, if you start your requests for information and then you get your results after 6 months or a year, it's just going to put you in a much better position in order to do the work you want to do. So that's the commercial for the regulator. And there's more information available on the Information Regulator website, as well as all the different rules and forms that you need in order to make the system work. So I think on that note, let me stop speaking, and I will hand back to the chair. Thank you very much.